this way if everybody's happy, sort of a change of pace. If you want to rearrange your tables, you're welcome, but we'll see how this works. Any questions about the test 1K? I've got the sample answers up there. I'm not sure about the first one, material that allows light to pass through it. If you assume material is solid or liquid, that works. To the extent you assume that there's air surrounding the hanger in the prior art, that air might be a material that would invalidate that claim. But it might have been better written solid material or non-vapor phase material, but that's a negative limitation, which wouldn't be so good. A blue object is fine. Nobody got into the particulars of what it means to be a blue object. You could have had a broader claim if you wanted to specify which frequencies of light are absorbed by the blue object that wouldn't be absorbed by any part of the prior art. But that got people into trouble. Some people said an object that reflects blue light, mirrors reflect blue light, silver-colored steel objects reflect blue light, and so the most common incorrect answer was a device that reflects blue light, because that reads on the prior art hanger. Titanium was an element found in the invention, but not in the prior art. Nickel is another one. There's no reason to claim those more narrowly, saying that a titanium alloy or nickel alloy. One clever response was an alloy containing at least 5 elements, which I thought was very clever. Body made of polymers, I thought also was pretty good, because you can't just say polymers or it would read on the acrylic glue. It's in the prior art, but if you recite a body made of polymers, then that works much better. Here is the handouts, and you can find your test in the pile of materials. So, any questions about what one or two of you, actually maybe 3 or 4 of you, wanted to focus on the rotation of the hook at the top of the hanger, but forgot to recite that the rotation has to be with respect to the rest of the hanger. And the prior art hook rotates along with the fixed hanger that is attached to it. It doesn't rotate within the body of the hanger, but it does rotate in any direction. It will move. You can lift it, you can throw it, and whatever else. So it's really critical when you write patent claims, if you're talking about an attribute of an object that relates to how it interacts with another part, that you recite both parts and show the relationship between those two parts. So while you're doing things, there's a handout and a sample answer and a test answer that you can get there, and that would be just fine to get that. One of the reasons why I'm reasonably generous in the grading of these and yet strict in the literal response that you give is that this is very hard to do when it's the first time that you've done it, and it is not intuitive. It is counter the way that you colloquially speak to one another about things. You say, I have a rotating hook. Well, yes, and when you say that, you're thinking in the context of the hook is rotating with regard to the body that it affixes to, but you have to actually recite those relationships when you write patent claims, or else somebody's going to make the claim invalid because it will read on the prior art. Okay, let's move on, if there are no more questions about the test, to our lecture on trade secrets. Trade secrets are really cool because trade secrets don't require lawyers. Trade secrets happen automatically, and you don't have to pay money to get trade secrets. It's a really nice form of intellectual property protection. More formal definition is information, including a formula, pattern, compilation, program, device, method, technique, or process that does two things. First, it has to derive independent economic value, actual or potential, from not being generally known and not being readily ascertainable by proper means by other persons who can obtain economic value from its disclosure or use. Now, that first item requires basically that it be sort of a secret, but it doesn't have to be a secret to everybody. Trade secrets can be known, they can be independently developed by different people, each of which keeps them secret. So not being generally known is a requirement, but there is no requirement that it's not known to anybody. Oftentimes in business, various companies have a whole lot of secrets that are not for publication, that may be the same secrets in part as one of their competitors has, but neither knows exactly what the other knows, and both of them can prevent the use of those secrets by third parties if somebody should steal it from them. Each of them could do that. Now, trade secrets not being generally known it can be defeated by going into a public library or searching the patent database and finding that thing which somebody is asserting to be a trade secret to be shown in a textbook or in an issued patent, and then you say, this can't be a secret. Here it is in an issued patent. And that would then extinguish any claim to a trade secret on that which is shown there. Normally, trade secrets are focused on more minutiae, where you would have a drawing, and the picture that's in the drawing is shown in an issued patent, but the issued patent doesn't have the dimensions and the tolerances and the source materials from which you can order the materials that are on the drawing. And it doesn't necessarily, for example, allow you to make interchangeable parts to something that's in the marketplace just by reading the patent. And so those fine details are generally protected by trade secrets. Now, if it's very easy to reverse engineer the product, where you can measure the product, then you can't really assert trade secret rights in those dimensions. But where there are tolerances involved and you can't tell from measuring one part what the tolerance band is, where that part has to fit into some other part, then the trade secret can have greater value, because then you'd have to get lots of samples of parts, measure them all, find out what the range of part variations are in order to duplicate that drawing that has those trade secrets in it. And so that would be a classic case of where a trade secret would have value, where interchangeability is critical and the dimensions and tolerances are not readily ascertainable simply by measuring. And the second thing is that you have to have some efforts that are reasonable to maintain the secrecy. One of the common things that is done in order to maintain trade secrets is to mark blueprints secret or confidential, so people know that you think these are confidential, and you don't put them in owner's manuals and give them out to the public, because that would then extinguish the trade secrets. You have to have reasonable efforts. You have to put people on notice that we think these things are secret, and you don't invite tours through to see all of these things that you think are secret. You have to keep people away unless they sign agreements to keep things confidential. And if you fail to use reasonable efforts to maintain secrecy, you lose the rights to enforce those secrets. That happens rather frequently. Now, if we compare secrets to patents patents apply to all persons within the territory. If I have a United States patent, I can sue anybody in the United States or its territories for infringing that patent during the term of the patent. I can do that regardless of whether they learned that invention from me and my patent or whether they came up with it all on their own. It doesn't matter. My patent gives me the right to that invention. Now, on the other hand, trade secrets only apply to persons who have a relationship with the owner, where the relationship imposes a duty either by contract or custom. So if somebody independently comes up with the same trade secret that I have, that's their trade secret, I have my trade secret, we're both happy. I can't sue them because they came up with it without violating any right that I had. Trade secret only relates to people who learn about your secret and then violate that condition of trust. Employees have a duty to maintain the secrets of the employer unless waived. So you don't have to have a written agreement that says, I'm your employee and thereby I will keep your secrets in confidence. The fact that you're an employee automatically gives you that duty to maintain the secrets of the employer. Now, of course, the employer has to have reasonable methods in place to make sure that these secrets aren't published or otherwise waived by disclosure to customers and the like. Sometimes vendors may have a duty to maintain secrets based upon custom. So if you're working on a development and you need to have an injection mold made, and you go to a company that makes injection molds, and you give them the details as to what you want the product to look like, normally the customs of the trade will impose upon that vendor to keep your specific dimensions secret. It's much better to have a written agreement, but if you don't, the likelihood is that vendor will have an obligation to maintain the secrets of your particular design. Doesn't mean he can't make a similar mold for somebody else who gives them their own blueprints, and he can make a new mold from that new blueprint that was independently developed, not using your own blueprints. But that's a custom of the trade obligation in addition to obligations of employees. You can also simply, by contract, agree between two people to maintain secrets. Just like a patent, a trade secret can exist in a combination of characteristics and components, each of which by itself is in the public domain, but the unified process and operation of which, in unique combination, affords a competitive advantage and is protectable. So we have the same thing with regard to patent claims and trade secret rights. Combinations of elements, each element of which is old, can provide trade secret rights and can also provide patent rights. Persons obtaining products or services supplied in violation of trade secret rights may themselves be sometimes liable, particularly if they were on notice of the violation. And some courts even hold that new employment may be prevented if there would be inevitable disclosure or use of trade secrets by the new employment. Most notably, you would look at the state of Texas. But trade secrets are not to prevent the use of one's skills of their trade. Avoidance of a patent requires an avoidance of that which is set forth in the claims of the patent everywhere within the territory that the patent has force. Avoidance of trade secrets is much easier generally because it can be done by a clean room independent development or acquisition from a legitimate third party who's not stolen the trade secrets but may have developed their own trade secrets that are very similar or identical. So you can either independently hire somebody to develop the very same thing. If you want to reverse engineer a product and you've been shown the drawings that have all these dimensions, for you to go ahead and reverse engineer it to yourself would subject you to challenge that in fact you used the information from the drawing that you were shown. So what you do is you give that product that you're trying to reverse engineer to a third-party independent laboratory saying, reverse engineer this. I'm not going to give you any information. They can do that. They come up with the nude blueprints from the product that they're reverse engineering, and then you can give those blueprints without fear of violating the trade secret, even though you were given the drawings under a confidentiality agreement, assuming that the product is otherwise on the market and generally available. Now, if the product that you're looking at and trying to reverse engineer is still secret, then that raises it to a different level, and there's no way around that other than to then have that independent laboratory try to devise that same product without giving them clues as to what the product is. And so that would be a more risky approach. But that's oftentimes used in industry where you have a compromised situation where you know about somebody else's trade secrets and you still want to develop products in that area, but you don't want to then be charged with violating trade secrets. You have an independent developer develop a whole set of trade secrets of your own, a whole set of drawings, a whole set of vendors that you use, and then you're free of any claim of trade secret violation. The term of a patent is fixed by statute, and patents expire in due course. Trade secrets end whenever the trade secret becomes public. They don't have a fixed term. Trade secrets could last forever, in theory. Or trade secrets could be extinguished tomorrow, or that very day, if something happens to otherwise publish that which it is that is secret. Patents are invalid without novelty. If your patent claim reads on the prior art, your patent claim is invalid and is not useful for asserting against anyone. Trade secrets need only relative secrecy. Maybe that other people know what it is that you have a trade secret in, but it's not generally known, so it's still enforceable. Patents are expensive to prepare and file and maintain, and they have a delay in their effective date. You can't really sue somebody for infringement of a patent until your patent issues. That may be 2 or 3 years after, maybe even more, after you filed your patent. And that's a long time to wait. Trade secrets require only procedures to limit access and notice to those having access, and they are immediately enforceable. You can discover a trade secret one day, have one of your employees go out and threaten to start a new business using that trade secret the next day, and you can be in court that next afternoon and get a temporary restraining order against them. You cannot do that with a patent. A patent is years away before you get a remedy. But trade secrets relate to those relationships more than the intrinsic value of the idea being protected. Patents have a limited number of claims. Trade secrets can often be defined in a myriad number of ways. Just as we wrote quite a few claims in our test 1, you can be looking at something that somebody says is protectable by a trade secret, and you can oftentimes write hundreds of claims to define conceptually what it is that's novel or what it is that's not generally known, even if not novel. And you can assert each one of those without having any patent office approval or anything else. And that's a very powerful way to get a remedy in a trade secret. And then the defense, of course, is each of these things that you've defined as not generally known, I can show you in a textbook or in an issued patent, or it would have been a routine, trivial matter to measure them. You're not entitled to protect something where the design around is trivial. Only one patent can have a particular patent claim. The system is set up so two people can't have a claim to the very same scope of an invention. But with trade secrets, more than one person can separately own a trade secret on the same invention. Now, if you elect to keep an invention secret, and a subsequent inventor later invents the same thing and patents it in the United States, you will have a defense to the infringement of that later person's patent only if you can show that you've had prior commercial use and you've continued that prior commercial use without abandonment, beginning at least 1 year before the earlier of two dates. The first is the subsequent inventor's filing date, or the subsequent inventor's public disclosure, if any. So you have to be a year earlier in your actual commercial use in order for you to have a defense to an infringement claim of a subsequent inventor. So you do run a risk of deciding that all of your protection is going to rely upon trade secrets if someone else soon thereafter files for a patent on the same thing, gets a patent to issue, they can then come and sue you for infringement, even though you were the first inventor and you had commercialized it, if you didn't commercialize it at least a year before that subsequent inventor filed for a patent or publicly disclosed his invention. If you elect to patent an invention, upon publication of the patent, all trade secrets that are shown in the patent are, of course, extinguished, because the patent, when it's published, is available for the public. Timeliness of claims. There is a statute of limitations for pursuit of damages for trade secret violations. In Indiana, it's 3 years. Most other states, it's 3 years, but in some, it is 2 years. And what that means is that if you've been injured by somebody who's stolen your trade secret, you have to sue them within 3 years of the time you've been injured in order to collect money damages for that particular injury. The statute of limitations for pursuit of damages for patent infringement is 6 years. So you can actually wait 5.5 years before you sue somebody for patent infringement and then collect all the damages for the last 5.5 years, assuming that there's a good reason for your delay. There is an additional principle in the patent law that says if you unreasonably delay before filing suit, you might be precluded from collecting money damages under equitable principles. But in any event, the statutes say you cannot in any event get money damages more than 6 years back in patent cases. You can still sue them, but you'd be limited to seeking injunctive relief and damages within the past 6 years. Any questions? The choice of whether to get a patent or to keep things a trade secret varies case by case. I've had one or two, actually two clients where they have had really interesting inventions where they've decided to keep the inventions a trade secret. And both of them have involved chemical processes which are not readily discernible by the finished product. And both of them have provided enormous commercial advantage by having elected to keep the inventions secret rather than seeking to patent them. But that doesn't happen very often. Most often, in the case of inventions that are going to be manufactured and sold, the invention can be discerned from looking at the product or seeing how it operates. And in those cases, the patent path is almost always the best choice. not always, but almost always, where the market is large enough to justify the costs for the patent process. So does anybody have any objection to leaving early today? The weather outside is really nice. I'm just wanting to see. Hearing no objections. You are?